Welcome. Thank you. Thank you, everyone, for being here. I think it's great, whatever folks' reasons are for being here. It's fantastic that you're engaging with the Legal Rights Center. One of our goals is to just be more broadly intertwined with the community, to share information, to spread information, to increase education. And obviously, it helps when folks come and we can have these conversations. So thank you very much for doing that. Today, it's my understanding we are talking about and having a conversation about the role of prosecutors in the criminal legal system. And I've sort of copped that term. I've taken that term, the criminal legal system, as opposed to the criminal justice system, because I think the more I've done this and speaking with other folks who've done this for years and years, it is more of just a legal system as opposed to a justice system. Justice implying that the correct things or the healing things are being done. And that's, in my opinion, and many others, just realistically not the case. So I use the phrase criminal legal system. You can take that to mean the criminal justice system as colloquially used. So talking about the role of prosecutors, if anyone has heard the phrase or sort of the saying that the prosecutor is the most powerful person in the room, they're absolutely correct. A lot of times folks think that the judge is the most powerful person in the room because they have the black robe, they have the gavel, they're the person who can impose sentences, they can rule on motions, they can set conditions of bail or no bail at all. And that's absolutely correct. They can do all of those things. But where this really starts in this adversarial system is with the prosecutor in terms of the court aspect of things, right? Folks' first involvement with the system are through police officers typically. And then after that police engagement in whatever capacity that looks like, then it gets turned over to the prosecutor's office who represents the state of Minnesota. You'll see on any court document in Minnesota, in criminal proceedings, it'll say state versus X. You might see in different states, they call it the people versus, a common one is the people versus OJ, right? It's not actually the people going after somebody, but it's that government entity. And the prosecutor's office represents the people in criminal proceedings. And I'm just kind of looking at this form sort of lineup that we've got here. So the first way folks sort of get involved and the prosecutors get involved is the charging process, right? So in Minnesota, charges are typically brought initially, they're referred for charging by the police, right? So let's take an ordinary situation where two folks get in a fight on the street. Someone calls the police and they say, hey, let's say it's Maleka beats me up, right? So I call the cops and I say, hey, Maleka, really pummeled me and she took my phone, right? I would call the police, and if Maleka was still there, they could arrest her, and they could hold her for up to 36 hours in Minnesota to decide whether or what to charge her with, or what to refer her for charging. So the police do the arresting aspect of things, and they will write up a police report and a statement of probable cause, and they will send that over to the prosecutor's office. Now, depending on what jurisdiction they're in and what level of crime it is, it might go to the city attorney's office, or it might go to the county attorney's office, or it might go to the attorney general's office, depending on the specific nuances of the case. But let's say it's a felony offense. For a felony offense, the officer would arrest the individual. They would write up a statement of probable cause. Probable cause is essentially the police's and or the prosecutor's short version of a summary of what the person is accused of doing. And they have to establish all the elements of the crime that person is alleged to have committed. Now, the police will write up a referral. They will send it to the prosecutor's office. The prosecutor will review the police reports, and the prosecutor will write up a formal complaint, and they will submit that complaint to a judge. A judge will then review that document, and if the judge believes that there's what's called probable cause, they will sign off on it, and that means that person has been formally charged at that point in time. So there are sort of two levels there, and I know I just went through a lot, but I'll break it down a little bit. So the police are sort of the folks who determine at the outset what people might be charged with, right? Police officers generally are, I don't know any of them. I don't think they're not lawyers. They don't have as much training as criminal lawyers have, but they know most of the criminal statutes. So they can go to a situation and they say, hey, based on what this person is telling me, I think they committed X, Y, and Z crime. They would send that over to the attorney's office, and the attorney might look at that and say, well, you know, sort of, but they're missing this element. But because I'm an attorney and I know these things and I do these every day, I can identify that they've committed a different crime. So that prosecutor might add on a different crime. Or if the prosecutor thinks that a person, that maybe the evidence is weak, if somebody has recanted their statement or given inconsistent statements, or there are no witnesses, a prosecutor, while they might be able to technically charge a higher level crime, maybe they think their case is weak, so they'll charge a lower level crime that they think there's maybe more proof of, right? So all of that said, the police have that initial interaction. And from that point forward, it's really up to the prosecuting attorney to choose and decide whether, what, and how to charge a person with. And that is called prosecutorial discretion. And that's just the beginning of their discretion, right? Discretion means the ability to choose, to make choices, right? They can choose not to charge somebody. They can choose how to charge them. They can choose how to pursue the case. So that's just the charging decision, right? So once they've gotten through the charging point, and let's say that that specific attorney keeps the case, right? So now that's their case and they're the one responsible going forward, prosecuting it, taking it to trial, trying to convict that person. The prosecutor also has the ability to negotiate a plea bargain. They sort of hold all the power, right? The prosecutor is the one who has decided to charge the case, not the judge, not even the alleged victim. A lot of times, and we see this on TV all the time, it's always a person saying, I'm going to press charges, we're coming after you, or, hey, don't worry about it, I'm not going to press charges. That isn't necessarily determinative of what is actually going to happen. Police and prosecutors will take into consideration what an alleged victim says, but they don't always listen to that person or follow that person's desire, right? And something that we see a lot, for whatever reason, someone can call and put in a police report and say, hey, this happened, I want something done. They can later go to the prosecutor and say, hey, you know what? Actually, that didn't happen, or didn't happen that way. Or I straight up lied. Or I was confused, or I was scared. I don't want that person to be prosecuted anymore. The prosecuting attorney can and often does ignores that person. And they say, well, that's great. We have to protect public safety. So I don't care what the alleged victim says. I think that that person is a safety risk to the community. So I'm going to continue prosecuting the case, right? And what a lot of prosecutors do too is they sort of play it both ways to their benefit. When an alleged victim says, I want something, you know, I want serious consequences, a prosecutor oftentimes says, you know, the victim really wants this, so I have to push for this. But at the same time, if the alleged victim says this didn't happen or I don't want this, a prosecutor will often say, well, I know they don't want it, but this person is a risk to public safety, so I have to go forward with it. So either way, again, it's not about what necessarily the people involved want, it's what the prosecutor wants to have happen, right? So that's sort of kind of a brief outlet and summary of how that gets going. So once the case is in, it's up to the prosecutor. The prosecutor then offers any negotiation or plea bargain. They can choose to permit an accused person to plead to a different offense, a lesser included offense. They can choose to offer a less severe sentence or penalty. Again, that's all up to the prosecutor. The prosecutor is the person who controls what type of sentence somebody gets if it's a plea bargain, right? if a person is convicted or if a person enters just what's called a straight plea, then that decision goes to the judge. So for instance, with the Chauvin trial, he took it to trial and he lost, and you saw arguments being made, right, to Judge Cahill. And there were competing arguments, and that decision was up to the judge. But 99% of cases, for whatever reason, usually resolve with a plea bargain. And that plea bargain is worked out with the prosecutor, who again holds most of the keys to power. So in a nutshell, it's sort of the police can refer charges to the prosecuting office, and then it's up to the prosecutor at that point to stick with those charges or choose additional charges or different charges to add based on their own reasons. Right? Another question is, so we've sort of touched on police there. Another sort of question is, how can a judge affect what's being charged? Well, a judge sort of can, but not necessarily. When a charge is brought up, that's not an adversarial process at that point. The prosecutor is simply the one who submits the document to the judge alone and says, "Judge, please sign this document. We think there's probable cause to charge this," right? The judge reviews that, and more often than not, even if there isn't probable cause, and we'll come back to that, judges will sign off on it if they believe there's probable cause on the face of that document, right? There's not a defense attorney there at the moment arguing about it. So if a judge reads something carefully, or or a judge thinks, hey, you didn't put everything in here that needs to be in here, a judge can decline to sign off on that document, right? Well, what typically happens then is the judge might tell that prosecuting attorney why they didn't sign it, and the prosecutor can sort of just go back and make those changes and fix it, right? So judges don't have a whole lot of authority in terms of what charges are given. Again, that's really up to the prosecuting attorney, right? And same with police. Police initiate the process, and they can say, hey, we think they violated X, Y, and Z statute. But again, that's really going to be up to the prosecuting attorney to run with that. So I sort of lumped this in. So prosecutorial discretion is saying, okay, one of the questions asked is, can prosecutors dismiss the case all on their own? And a follow-up is, why do we not see more dismissals given the knowledge of mass incarceration? So the short answer to that first question is yes. Prosecutors can absolutely dismiss cases all on their own. They have the authority to do that. And it's Rule of Minnesota Criminal Procedure 30.01. They can dismiss a case and they just have to provide a reason for it. Sort of a vague, amorphous reason is what's called in the interests of justice. So maybe they found out, hey, this alleged victim lied and we know that they lied. Or, hey, this person had an alibi. They were out of the country when this happened, right? So they can choose to dismiss the case that they've charged. And the reason they're giving is for the interests of justice, right? Sometimes they get very specific with their reasons. If it's a case where they need a witness to show up and testify, and that witness chooses to ignore the subpoena and doesn't come testify, meaning the state can't go forward with their case, the state could be forced to dismiss, because if they don't have that witness come testify, they can't win their case. So maybe they dismiss it. And they choose to write up in their 3001 dismissal, we're dismissing because the witness didn't cooperate, right? Take your pick, whatever reason they want to think of, they can give that reason, because again, at the end of the day, they're the ones who have the authority to actually make a case go away if they want to, right? The follow-up with that is, why do we not see more dismissals given the knowledge of mass incarceration? And I want to, and that's the billion-dollar question, right? There is no single good answer or any single answer to that, right? And I'll sort of share a broader scope of what a prosecutor's obligation is to the system, right? So according to the American Bar Association, a prosecutor has the responsibility of a minister of justice and not simply that of an advocate, right? We are in an adversarial system, meaning you have a defense side and a prosecutorial side, and they're battling, right? One side is trying to be found not guilty. The other side is trying to prove that person guilty and give them consequences. We're fighting, right? It's not a collaborative process. We're not working together. We're, particularly in COVID, we are referred to as partners in justice, meaning you have the bench, the prosecutors, and the defense attorneys. I disagree with that term partners because that implies some semblance of equality, which is very much not there. But yeah, we're fighting, right? It's one versus the other. So prosecutors have the ethical obligation of not just being an advocate, not just being for their side, because their side is justice, right? And the question is, how does that, or does that play out in real life? And I think the answer is very much no, right? And I'll add a bit to that to sort of expand on that. So I just had the quote here. Okay, so another way to put it is to say that the duty of the prosecutor is to seek justice, not merely to convict, right? They have to make sure a defendant gets a fair trial. They have to make sure that the evidence is what it, stands up and is supported by proof there. And prosecutors don't dismiss because I think we can look at the historical beginnings of the system, and that's probably a conversation for folks more learned than me or a different session, but we are not in a system set up to dismiss cases, to have people not involved in the criminal legal system. That's not how or why or what our system was set up to do, right? Our system was set up specifically historically to get people ensnared in it, very likely specific people, more so than others. And that's what we see with mass incarceration. And even if there are individual prosecutors who maybe feel more strongly about their role in finding justice and doing societal good versus winning, they have bosses too. And sometimes their bosses don't let them make that decision or will punish them if they make that decision. So it is systemically set up to not have things go away, right? And that is sort of ugly, but it is true at the same time. Let's see, what powers does the system have against erroneous prosecutorial discretion? Really none. Unfortunately, there's not a lot, right? Prosecutors and judges generally have immunity unless there is, if folks listened, I think it's on NPR, it's a podcast, and I believe it's State v. Flowers. It's a man down south. I can't remember which state, but he had been prosecuted or put on trial, I think, 6 different times. And the prosecutor, and they were either, I think they were all hung juries, meaning a jury couldn't make a decision either way, or else he was, I can't remember all the details, but he was prosecuted and put on trial 6 or 7 times. And the prosecutor is established as having, I think, hidden evidence or withheld evidence and just done a bunch of very unfair things. But he's still permitted to continue prosecuting that. Okay, thank you. Yeah, Heidi. He was convicted twice and overturned on appeal. So yeah, so even worse, he's been through this ringer multiple times. And what has happened to that prosecutor? Really not much, right? So yeah, you can file an ethical complaint, but there's a wide amount of latitude to say, hey, even if I was wrong, I thought I was right at the time, or I had a somewhat reasonable basis to believe this, right? And I'm just seeing Linda's with the private law firm prosecutors. Yeah. So yeah, there's not a lot of recourse, right? And if there is recourse, it takes a lot of time and it can take a lot of money to get that end result, that positive end result of saying, hey, here's how we can correct this wrong, right? Another one says, do judges or attorney generals hold prosecutors accountable for their actions? If not, who would hold them accountable? I think, in my opinion, no. But I think there's context to that, meaning I think what I personally and what many members of the defense bar view as prosecutors doing or not doing the right thing. And I'm not even talking about the ethical thing or the legal thing, just the right thing, is very different than I think what they view as the right thing. So even if I think something's not right, that maybe doesn't rise to an ethical level or a malicious level, right? So again, sort of the recourse is typically maybe the case gets dismissed or maybe you win at trial and everyone sort of moves on, right? That's what can happen a lot of times, particularly if there's bad police action. Prosecutors often dismiss the case if there's bad police action, and everyone is just expected to sort of move on, right? That's the remedy, is that you don't get convicted and you don't go to prison, as opposed to here's this change that we can make, right? And I think something very telling about the Chauvin trial was it was very telling that the state opened up much of their case and closed much of their case by saying this was a pro-police prosecution, right? And sticking with that sort of bad apple, as opposed to, hey, there's a general wrongness here. So even in that's the case, it's still sort of pulling their punches as to how do we correct these general bad actors. And I think judges don't necessarily want to invade the province of scolding prosecutors. And I don't always know if it's appropriate either. As much as I might like to see it sometimes, I just don't know if it's always ethically mandated or appropriate. But in terms of who can hold folks accountable, I think it is really the people, right? The county attorney position is an elected position. And if you can run or support folks who are running who are more minded in the direction that you are, that is a way that you can get in there and help affect change, right? And I can't, is it San Diego? Someone will know this. I don't know if it's San Francisco or San Diego. I want to say San Francisco. There was a new prosecutor there, and I think he was a career public defender before that, and he ran and he won and became the county attorney there. And he walked in and essentially cleared house, and or most of the managers chose to retire. And I think looking at that, and again, no one is saying, yay, go in and fire everybody, but it's saying, look, that was a big change, right? To say there's a new boss with a different way of doing things. And he either decided, oh, am I still there? Okay, I'm sorry, I'm noticing my audio was disconnected, I'm sorry. So you have a new boss and they're either bringing in people to do things a different way and or other people are choosing to leave who have been doing things the old way. So for example, in Hennepin County, we have Mike Freeman, and if he is voted out, that would mean, or if he is not reelected, that would mean a new person comes in. And if a new person comes in, that means new line attorneys, that means potentially new managing attorneys, right? Who could choose to help do things a different way. Realistically, in my opinion, that is the most effective way to actually get day-to-day change, as opposed to asking, an attorney general or a judge to step in. That's not really realistic or practical, unfortunately. So I think having change from the top down in terms of the leadership and whoever they bring with them is an effective way to institute change. And Linda, two great points. So the first one that Linda said, and in case folks don't see the chat or haven't seen the chat, there's a comment from Linda saying, I have never heard of private law firm prosecutors until I came to Minnesota. Can't get how this is happening because this is prosecuting for material gain. Shouldn't this be unethical? In California, we don't allow private law firm prosecutors. Prosecutors are with the county, not even the city. And noted that the Woodbury Prosecutor is a law firm in Hudson, Wisconsin. So someone not only are they private, but they're not even in the state of Minnesota, seemingly. So yeah, that is, we've heard that that's a unique thing to Minnesota, and it definitely raises an eyebrow, as it should raise an eyebrow, right? You have someone who, and I think you can find their contracts online or through a data request. But essentially, many of these law firms have either guaranteed financial contracts with the city, or they can bill hourly. And if someone is billing hourly, it's likely that that person does have an objectively financial-based interest in extending proceedings, right? So whereas another prosecutor might choose to dismiss a case or offer a resolution to the case that is maybe more palatable, there's at least an eyebrow to be raised that that prosecutor is billing hourly. So maybe they are dragging it out to just make more money, not necessarily seeking justice. Maybe, right? I don't know that. But it's a concern that is objectively there and in play to be considered, right? And Linda also said, how did Mary Moriarty lose her job? She was chief public defender. That was, I think, a very political process that I don't know enough about and was not involved in enough. So I don't want to put my foot in my mouth by saying anything I don't have objective information to share with. So I think you can find articles online and sort of see how that came to be. But yes, that absolutely was a controversial, and I think continues to be a controversial decision as to how and why Mary Moriarty was removed. Mary Moriarty was the chief public defender for Hennepin County, in case folks don't know who that is. And yes, Linda, again, I think that's like a police officer getting a kickback for writing tickets. Yeah, you know, it's always concerning when there's a financial interest at stake. You know, and I think there's also that general sense of, okay, you know, as much as we battle with county attorneys or city attorneys or attorney generals or whomever, you know, there's the, I think, ethereal notion that they are at least public servants, right, as opposed to a private firm whose goal is to make money, right? And maybe it makes financial sense for a city, you know, for a smaller city to hire out and contract with a private law firm. But my response or my opinion on that is, well, if you don't have the money to do it, then don't do it. So it's prosecuting and involving folks in the legal system shouldn't be done in a way that is simply economically convenient. That seems wrong to me. Yeah. Yes. Yeah. And there are many of them within Hennepin County. Absolutely. So I'm probably over my 20 minutes. I'm sorry. And I hope I answered all the questions. If I didn't, I'm happy to stick around and answer more, or I can join some of the groups and see what other folks think. But big picture, I think the takeaway here is the prosecutor is an incredibly powerful person. And obviously, as a defense attorney, it's our job to advocate for people and fight for people. And we can be sort of a check on some of the things that they're doing. But I think ask any defense attorney, and I think your opinion will be that prosecutors generally play to win, as opposed to playing to do the right thing. So I'll leave it at that, and I'll turn it back to the folks who know what they're doing.
Awesome. Thanks so much, Nick. Really appreciate all of that information and the way that you've teed us up for some really powerful discussions in our breakout rooms. So we're going to spend probably around 35 minutes in these breakout rooms together, discussing, what we've heard about the role of the prosecutor, and then thinking about our roles as community members. How can we be a part of changing a system if we feel like it needs to be changed? So before we go into breakout rooms, we just want to quickly review some discussion guidelines. We ask that you will treat each other online as you would if we were sitting together in our office at the Legal Rights Center, which includes being tolerant of different people's viewpoints, disagreeing respectfully when you do. We ask that you respect the privacy and the personal information. If you'd like to share a personal experience, we want to make sure that you're able to do so and not feel as though that your information is going to be taken out of context out of this space. We ask that you communicate with courtesy and respect, and that also means allowing people to finish their thoughts, so not interrupting one another. We ask that you speak from your own experience when you can, rather than generalizing, and at the same time, assuming that you're speaking about the reality of someone in the room. We might have some prosecutors here. We'd love to hear your perspective on what was shared. We ask that you keep yourself on mute, and if you're able, turn on your camera. We'd love to see your faces, and then use the messaging and chat function responsibly. Certainly a fine place to have some additional conversations, but we don't want it to be distracting from anyone who's sharing. So you will see, I'm going to stop recording now since we're going to go into breakout rooms.